So thank you everybody for being here. Here at Melbourne Law School, we are standing on the unceded lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders past and present, particularly in this very historic week when the Victorian Parliament is considering the statewide treaty bill. So I'm going to speak just for a couple of minutes to introduce, and then we're going to have got a pre-recorded video that Philip Britton has given for us to say hello to you all. And then we're going to introduce and to hear from Margaret Lothian, who's awesome. So we'll hear from Marg, and then I'll give you about 10 to 15 minutes on the current reforms in Victoria. So you get your quarter of a CPD point or something like that. Now, we are here tonight to launch, at least for the Southern Hemisphere, the second edition of the Residential Construction Law book. Now, we do have a few copies of them, and I mean just a few. So if you'd like to, Naomi, behind you there is a couple of books. Yes. Oh, thank you, Rosemary. So we have just a few copies to sell. The way that things work now, at least with Hart Publishing, is you have to buy the books and then they print them and then they send them to us. So it's not like the old days where you get a consignment of them. So we only have a few, which means that if you would like to buy one, if you trundle over to the table there and there's still one there, all you need to do is transfer the money to me. The instructions are there. And if you'd like to order one, there's a discount code through that QR code. It's available in both hard copy and also in an ebook version. All right, so it's a great pleasure to have you all here with us tonight. Particularly like to acknowledge our distinguished guests, including Judge Suzanne Curtin and Kathy Aird. We have Professor John Sharkey with us here tonight as well. And of course, we've got members of my family, and we've got both the Director of the Melbourne Law Masters, Professor Andrew Godwin, and the Director of our Melbourne Centre for Commercial Law, Rosemary Langford as well, Professor Langford. So tonight is being hosted by our Melbourne Centre for Commercial Law. If you'd like to learn more about that, you can see our website and indeed have a chat to Andrew or to Rosemary or to Wayne Josick, my co-director, or myself. All right, so without further ado, I would like, if we can, to introduce you to Philip Britton. Now, I'm going to say a few more things about Philip, and look, I mean, what can I say about Philip? He is the most remarkable person. He's a polymath. He's incredibly generous, and I think there's a great deal of generosity in the way that he has laid out so much of this text. I have had a few things to do with it, but a lot of the work is his, including telling the stories, and I know, Marg, you're going to speak to this as well, of all of the angst alongside the hopes that we can have as the users and consumers of residential building work. Anyway, let's have a listen to what Philip's got to say for a couple of minutes.
Hello everyone, I'm Philip Britton, co-author with Matthew Bell of this second edition of Residential Construction Law. And of course, I would much prefer to be with you in Melbourne tonight than in autumnal and slightly sleepy Suffolk on the east coast of England. This book came, as you know, this being the second edition, out of an idea that Matthew and I had that residential construction law deserved proper attention as a topic, both because we knew that there was, at least in Australia, quite a lot of law specific, both to individual states, but also to the topic of residential, or in some cases, as you know, domestic construction law, as you call it. And that this raised issues of regulatory effectiveness, of interference with contractual, tortious and property rights, and a whole range of issues, all of which we thought weren't adequately discussed in print. And the general rule being, if you really want to understand something, write about it. And that was how the idea of writing a book came. And of course, it came also out of the pioneering residential construction law subject within the Melbourne Law Masters. having decided to do that, life kind of overtook us on a number of fronts. There was, of course, the Docklands Tower in Melbourne in 2014, and worse yet, and even more dramatic, was Grenfell Tower in London in 2017. That has meant that the framework, meaning in a sense all of it, has been transformed by new interventions by legislators and regulators. The common law itself hasn't been unchanged in that process. And so when it came to doing a second edition, almost, I would say, half the book had to be very substantially revised and rewritten. And that's the edition that you've not now got in your hands, I hope. Worse than that, speed of change has continued to evolve, particularly in Victoria, since we put the book to bed in about the middle of this year. And so, as I'm sure Matthew will explain to you, we've therefore taken up an invitation to add an online update resource, meaning that we have already added something like 27,000 words of additional material available via a QR link on the back of the book. So this is, as all books are, a kind of work in progress, but we're confident that it represents, at least at this moment, the best summary, and the best summary across the range of jurisdictions which we've chosen to represent. It's already clear to all of you how radical are the differences between the states of Australia. We add in, for special interest reasons, New Zealand, which has, as you probably know, gone its own way in very interesting ways in relation to tort liability. We have to add in Wales as a separate jurisdiction, since building control is done separately there. Scotland is already a semi-civil law jurisdiction, and it would be rude not to include Ireland. So the work is, in every sense, comparative, and we believe that that gives food for interesting analysis and interesting picking of, as it were, the best bits of intervention from across the jurisdictions that we talk about. So I wish you a happy evening. There aren't a lot of jokes in construction law. There are great stories, but there aren't many truly funny aspects of it. However, you have Marg Lothian with you, and that guarantees jollity in every direction. So have a great evening.
Thank you, Philip. And I just thought I'd give you a very quick tour of what the book is doing within its 846 odd pages. And what we've really tried to do is to conceptualise what residential construction law looks like as a distinctive area of law. And it is, I think, the first book that does that in any systematic way around the world. But in doing that, of course, as with any book, we need to try to explain what all of the legal landscape looks like. And it is one of those areas, and Judge Curtin and I are about to teach 5 days on this, it is one of those areas which combines all of the different areas of law, including, of course, the case law, and much of the common law is covered in those early chapters, but then also large amounts of overlay by way of regulation. And finally, the standard forms and the ways in which we do things within the industry as well. So all of that is in there, but the first thing that somebody asked me the other day when they saw we'd written a book on residential construction law, they said, "Oh, great, I need a book on strata and I need a book on owners corporation." And we said, well, sorry, this is not that book. There are bits, of course, particularly towards the back of chapter 11, which deal with a lot of the buildings around us by way of strata and owners corporation issues, but somebody else can write that book as well. All right, so that's the kind of sequence, and then the book itself is in a fairly standard format, but there are lots of good stories in it, as Philip has mentioned, and even though it is, and we hope it's a rigorous legal text in its analysis of those different legal areas, we also hope that what comes through very strongly is the emotional and the human side of things, which again, Marg, you've taught us so much about over the years. And because it's all very complicated and we didn't want it to be 1,200 pages, We have got lots of comparative tables, if it's a useful thing for you as well. And finally, we have lots of diagrams. And I particularly want to mention that because Philip has got a beautiful eye for the aesthetic. And so he was particularly keen to get these lovely diagrams in there, which can often help. Now, the last thing that Philip mentioned as well is that we are well into whatever the next stage is of this book, and you can be part of it. In fact, it's a publicly available website at this stage. The publisher's monitoring that, but we do have a website which has got much in the way of Daughter and Sharky and loose leaf services. It goes through the book and gives you an update by paragraph of things that we've noticed. And some of those things have just been in the last week or so as well. So there's always new things going up there. So we hope that that's a useful public resource, and hopefully there'll be a third edition in good time. But here tonight we are delighted to be launching the second edition, and so glad, Marg, that you're with us to do that. Now, I think it's fair to say that for most people here, Marg, you need no introduction at all, which is why I'm simply going to say, and I know you're going to tell us a little bit about your background as you go through this as well, simply to say that we're very chuffed to have you and Peter here tonight, and you and Kathy, Judge Curtin, are legends of our construction law community, and you have many years, may I say decades, of experience, including as a senior member and principal mediator at VCAT, where you were described on your alleged retirement a couple of years ago as a, quote, tribunal chameleon. You're also very much a friend of the show here at our construction law program at Melbourne Law School, having contributed over many years, as you would say, to misleading the young. Yes. Well, we do that very well here. And Marg, thank you so much.
Many thanks. It's a great pleasure to have been asked to launch this book. We building lawyers know that other people think we're a bit strange. Lawyers either love building or hate it. And I have had the very good fortune, along with Kathy and Suzanne and, oh my God, John Sharkey, to love it. I had the luck to have spent time during my articles of clerkship working with the legendary Jeff Mazor, followed by an innings as first legal officer of what was then the Royal Australian Institute of Architects. I refer to it as the Republic of Australia Institute of Architects, and I see they've dropped Royal. Well done, boys. I was a founding chair of the House Contracts Guarantee Fund Appeals Committee, where I met the brilliant and extremely young, we've established that she was 12 at the time, Suzanne Curtin, now Her Honour, Judge Curtin of the County Court, and then my dear friend and colleague Kathy Aird and I were both founding members and mediators of the Domestic Building Tribunal, which was one of the tribunals that came under the VCAT umbrella on its foundation. I have, as has been mentioned by Matthew, also enjoyed misleading the young. And in years gone by, I had the pleasure of speaking and role-playing in the compulsory conference or mediation parts of the Master's Residential Construction Law course run by Matthew with Suzanne, and until recently with Philip as well. That's more than enough about me, and nowhere near enough about Suzanne and Kathy, and others who are here this evening, including, of course, John. The context is that I love good design, I love good construction practice, and I've seen far too much of the consequences for everyone involved in building, especially domestic building, when it goes wrong. Like many here, I'm passionate about trying to minimise the technical problems we see and minimise the cost and agony of domestic building disputes. And as we all know, it's not easy. The price of domestic building perfection is that some people are homeless. But homes need to be safe and comfortable. Particularly, they must not collapse or be consumed by fire. They must be dry, a problem that's exercised the minds of our colleagues in New Zealand. And ideally, they should be able to be heated and kept cool at a reasonable cost. And when thinking about water ingress, It's long been my view that if building professionals could get waterproofing, tanking in bathrooms and on balconies right, then it would probably cut the work for domestic building lawyers by about half. Building litigation is frequently expensive. It's not unusual for parties to include the builder, the owner, of course, and it can include some or all of the architect, the relevant building surveyor, engineers, both civil and geotech, and an unhappy collection of subcontractors. Proving and defending each case can require the services of experienced building lawyers and a variety of experts. When the litigation is about one's home, there's an extra layer. As Philip and Matthew have said, home usually has an emotional component going beyond anything ordinarily expected in an arm's length commercial transaction. It's important that the cost of litigation, whether financial or personal, is proportionate to the amount that's in dispute. Hands up every time we've mentioned toxic costs, often. Toxic costs are where the cost exceeds the amount that's in dispute, and it's far too common. Disputes should be able to be resolved quickly, but that's not always possible. There are some rascals among the usual parties to litigation. We're all familiar with tales of wicked builders, but they're not alone. Developers that pop up for a particular project, allegedly finish, collect the money, then liquidate it at arras gouge. Then there are even owners who occasionally attempt to commit theft by litigation. They don't make the last payment, then sue for largely imaginary defects. I once came across a woman who was telling me quite proudly that she never made the last payment. My response was, tell me why that's not theft. My own experience is that there is more incompetence or sheer bad luck than dishonesty, although dishonesty can creep in when people are trying to protect themselves. As has often been said by Cathy during her leadership of both the Building and Property List and the Commercial Claims divisions of VCAT, we do not forget the people behind the disputes. With the exception of a few more than averagely persistent litigants, nobody enjoys litigation. And then there are the tragedies and the near tragedies. The Grenfell Tower disaster was discussed in the first edition of the book and considered further in this edition. Almost everything that could go wrong did go wrong. Those who could have acted failed to listen to the tenants who reported obvious defects, and residents were told to shelter in place and wait for rescue. As the authors state, within minutes, the fire had spread into combustible aluminium composite material, facade cladding, and other materials, leading to the deaths of 72 occupants of the building. The La Crosse fire could have been a similar tragedy in Melbourne, but fortunately no lives were lost. And then there was the Opal Tower in Sydney, and we seem to specialise in having disasters on Christmas Eve. On Christmas Eve 2018, an almost new Sydney apartment building, Opal Tower, was evacuated after residents heard a loud bang. Cracks were then discovered, including a load-bearing panel on level 10 of the building. The experts' report identified as primary causes of the failure under design, partial grouting, and other construction and material deficiencies. The fires and perhaps the Opal faults were substantially due to the use of new and insufficiently tested materials. A number of jurisdictions have introduced legislation to attempt to ameliorate such risks. But does that mean innovation should be halted? I know that the family of one set of my great-grandparents were rural pioneers of European origin who lived in a slab hut with a dirt floor. Not ideal, but it was shelter. And that's what we need. We need shelter as well as food and clothing. Another great-grandfather had trouble with what passed for a local authority because the sinful modern water closet, which drained into a septic tank, was inside the house and was deemed to be a cesspit. You can't have a cesspit in the house. The same house had a kitchen separate from the rest of the house because of the risk of fire. But what would have happened if the aluminium composite material had been widely used in London at the time of the Blitz, or Kiev now, or in Melbourne's north on a bushfire risk day with a rated catastrophic with an ember attack coming from the north. An important consideration is the cause of the loss or damage. Mother Nature can be a harridan, and some of what she does is uninsurable. For example, inundation from sea level rise combined with increasingly energetic storms. These are issues that will need to be taken into account to minimise cost and risk of climate change. We might succeed, but we might not. However, there's a real and justified sense of grievance if the person behind an investor profits while homes are lost. I steal from the authors to tell you what this edition is about. The central theme of the whole book, construction defects, widely defined, in homes and in buildings containing homes. How do they occur? How might they be prevented, but also cured? The cure aspect may be the immediate reason for reading the book. A homeowner or resident faced with a building problem or other disappointing outcome wishes to know what legal or other pathways are available to rectify this or gain compensation. Others will look for help in preventing defects in the first place. Homeowners or their advisors embarking on a project, industry professionals looking to navigate potential legal exposure, or policymakers alive to the possibility, necessity even, of doing better, eager to learn how other jurisdictions manage identical issues. We, the representatives, the litigators, the judges, the tribunal members, the public servants and the legislators are trying our best to overcome the problems of costly and life-destroying litigation. But there is no automatic cure, and sometimes we must look at our attempts and admit that they have not been successful. We must be willing to look at what we've done and assess it. Has it improved our homes? Has it simplified or complicated the lives of building industry professionals? Is it driving mum and dad builders out of building, leaving mum and dad owners to contract only with sophisticated builders? There are many of us who have looked at the process to see if it can be simplified and shortened. Sometimes powerful defendants use their superior knowledge of legal procedure to cause cost and delay to plaintiffs and applicants, particularly those who are self-represented. And it's not unknown for expert witnesses to be partisan, often because they're over-enthusiastic, but sometimes because they are biased by their franchise. Those of us who facilitate joint expert meetings or expert conclaves tend to educate and emphasise the expert's first obligation, which is to the court or the tribunal, rather than to their client or the instructing solicitor. Life for domestic building litigants in Australia is far from ideal, but one thing the book demonstrates is that we are, in most respects, doing as well as other jurisdictions. In Victoria, we're very lucky to have the Master's course. We're also lucky to have been where the Building Dispute Practitioners Society was formed in 1979. All Australian building lawyers of a certain age also benefited from the then Bible, Daughter and Sharkey's Building and Construction Contracts in Australia. Well done, John. This book continues the tradition, and we thank Matthew and Philip and their special contributors, Deirdre Nifloin and Kim Vernau, and I think I've probably mispronounced Deirdre's name. My apologies, Deirdre. It is a step on the way to finding the balance between caring for the consumers and not harming the builders we want to have, those who take pride in their work and do the best they can for the benefit of their customers. And so we must keep watching, considering what is happening, thinking about whether it's in the best interest of homemakers, homeowners, and all those who contributed to designing and building these homes. This book is the product of the sharp eyes and the intellectual rigour necessary to keep that watch. It's important for all of us who practice or teach in the area and for all who regulate and legislate. I commend it to you and have the pleasure of declaring the second edition of Residential Construction Law of the UK, Ireland, Australia and New Zealand launched.
Well, thank you, Marg. I'm going to have a few more words to say to you shortly. Do I want it back? Oh, well, let's keep it here. But there may be another one lurking for you somewhere. So For the next bit, I just wanted to give you a little update, and I think most of this is going to be very familiar to most people in this room. But even this afternoon, the Legislative Assembly has been debating the reforms to the security of payment legislation, and actually, quite interestingly, having a look at that and also Hansard, I don't know, but it looks as though the opposition is not going to block try to block the reforms going through. But what the opposition has been saying in all of their speeches is there are so many other things that also need to be done. And of course that's right. So from that point of view, we are in a moment, and 2025 very much is that moment where in Victoria, a lot of the reforms which have been on their way for a very long time, and a few that we hadn't foreseen before the Parliament and making their way through the Parliament as we speak. Now, most of this has actually come in the context of the government's desire, which is not just the Victorian government, but all the governments around the country, to increase housing supply. And the government is currently committed to delivering 800,000 new homes in the next decade. It's a lot of homes. And this is the umbrella under which they're saying that that increased supply can be made. So I guess from my point of view, Phillips and many others of us in the room together, there have been a few things that we've been suggesting need to be fixed over the years, and this is the vehicle of housing reform that the government's now using. One of the things that I think is encouraging is that there is a multi-pronged, holistic approach from the government. They're not simply saying, oh, we're going to, I don't know, put all building surveyors back into being municipal building surveyors, or we're not going to, we're going to abolish different types of insurance or whatever else. There is very much a holistic approach. And if you're not familiar with it, just in the next 5 minutes or so, I'll give you a bit of a tour of those things. So the first major piece of legislation that came through this year in this space was the Building Legislation Amendment (Buyer Protections Act). Seems like one of the things we've adopted from the United States is that every act now needs to have some cute name to it. And it's not just about buyer protections. There's a lot of other things going on in here as well. But certainly it's the idea behind it is a lot of what Bronwyn Weir and others have been talking about for a long time about building confidence in the industry. So the main thing that's happened already out of this act is the Plumbing Commission, not planning, as a one-stop shop to replace the Victorian Building Authority. That's already happened. And it's brought within its doors the domestic building insurance, which was with the Victorian Managed Insurance Agency, and dispute resolution via our friends at the Domestic Building Dispute Resolution Victoria, and hopefully some increased resources for DBDRV as well. Perhaps more controversially, but brought to us from our friends north of the border in New South Wales, is a developer bond scheme, whereby developers will have to pay or put up a bond for 2% of the contract value, which will be retained for 2 years after completion. And for those of you who were tracking this bill as it went through Parliament, the only change that was made, despite a lot of objections from the opposition, was to say that it was a typo from 3%. They actually said it's 2%, but we'll see, because it's going to 3% in New South Wales. Now, what hasn't had so much publicity, I think, is the Victorian government is quite explicit that they're going to follow New South Wales' lead and make this developer bond a pathway to decennial liability insurance, which those who are familiar with the French system is actually a product that's available and made compulsory on, in our case, apartment buildings. So that's on its way as well. Of course, there's a lot of work going on in the background with the Insurance Council and others to make that a viable product. The next big thing that came through in that act was very significant new rectification order powers, again, largely reflecting what's gone through in New South Wales over the last few years, including retrospective actions under that, and the replacement or the enhancement, I think the government would say, of the existing domestic building insurance scheme with something that they're calling a statutory insurance scheme, but which is to have a first resort capability alongside the well-known and deficient triggers for the builder having to be died, disappeared or insolvent. So that also is on its way. Then, and this Act was given assent to just a couple of weeks ago, sorry, last week, no, I've lost track of time, Tuesday. What day is it today? Was the Domestic Building Contracts Amendment Act, and that, of course, is our bread and butter. Largely, we're looking at the Domestic Building Contracts Act in the residential construction law sphere. Many things have gone on here. There's quite a bit of tweaking going on, but there's also an extension of certain types of warranties to developers explicitly. There has been a response to the infamous case perhaps, of Mann and Patterson a few years ago to tighten up the way in which variations work, and also various changes around cost escalation clauses. So it's taken a while after COVID for the government to be listening to that, but they now have the ability to have cost escalation clauses increase there as well. But there's also significant changes, which I'm sure we'll be looking at in our more detailed course, about the way in which disputes are running. Now, there's a lot of other things in there, but I think we'll post these slides for you if you're interested in the detail, and many firms, including yours, Damien, have been writing about this, Michael, in your firm newsletters as well. So there's a lot going on in both of those major pieces of legislation, but we shouldn't lose sight of this being holistic reform, that there are many other prongs to this very large wheel of reform that's going on. So the next thing that we're looking forward to, I think, is the regulations, potentially ministerial orders, which will be where the rubber hits the road when it comes to insurance and other things under the Bioprotections Act. There will be a lot of other regulations coming through, a lot of things that were said by the government. We'll push that into regulations in the usual way. And I think it is also relevant to note the security of payment reforms. Now, the government accepted what are called the Tranche 1 reforms, which were largely to bring Victoria into line with Western Australia and New South Wales with John Murray's report. But there are certain other things which have been left in the not quite too hard basket, but have been left for Tranche 2, and there are consultations going on in relation to that, including very significantly for us in this sphere, which is whether security of payment legislation will apply to the homeowner's contract with the builder across the board. At the moment, there's a complicated regime, which many of you are familiar with as well. The government retains its ambition to have a whole new Building Act. They haven't resolved from that as yet. And that's been something part of the building system review for several years. And of course, there'll be an election due next year in November. So there's a lot going on in this space. And for that reason, I'm very happy that if you have got any contributions you'd like to make or suggestions, or maybe even just draft up a little bit for us to help us out when we're doing that ongoing painting of the Sydney Harbour Bridge with that update document, that will always be welcomed. But finally, and I'm going to hand over to my colleague, Rosemary Langford, to wrap up in a second, but I'd like to just give some thank yous. Firstly, Marg, thank you so much. I'm so glad that you could be with us, because you really get this stuff and you get why we wrote this book, and there's so much of you and Kathy and other people in this book, and that's your copy. Thank you. It's an actual book, so thank you, Marg. Yes, absolutely. I would like to thank my family, my wife Melinda and our kids, Emily and Christopher are here. So this is, I promise this is what I was doing when I was in the study all those times. And thank you for all your support. And indeed that we've done lots of renovations at home over the last 10 to 15 years. So we've had plenty of experience doing that. And my dad's here as well. So, and I think I can tell the story, Dad, that we brought home my third brother, I think, to a building site when those renovations were supposed to be finished. So I got from an early on, I got an understanding of how inconvenient it can be when residential building renovations don't finish on time. So Diane, I'd like to thank you as well and our wonderful events staff for making all of these things happen. If you don't mind some chocolates, there you are. Thank you, Diane. These things don't just happen, as you know. And finally, you know, I really just want to thank everybody who's contributed to the book. Wayne Josick, many people here, you'll find bits and pieces that you've told us over the years. We have written them all down. If you've been on LinkedIn and you've talked about an interesting case, then that's found its way into this book as well. I think I looked it up. There's 27 references to LinkedIn, so I don't think there's many law books that have got that. No references to Wikipedia, but some to LinkedIn. And finally, of course, to Philip. None of this would have happened without him, his vision and his real generosity in wanting other people, all of us, to understand just what a complex area this is, and you really put your finger on it before, Marg. A lot of what we do in the law is looking back and saying, here are the things that went wrong. And hopefully from the things that go wrong, we can not just, as so many of us do, just put our heads in the sand and hope that everything will go right, but we can be communicating with each other. We can be having as many tenders as we possibly can before we go with the cheapest price. And we can be sanguine about what the prospects are for dispute resolution when there may be some scuffs on the skirting boards and those sorts of things as well. Anyway, thank you all very much indeed for being with us, and I'll hand over to my colleague and the director of our Melbourne Centre for Commercial Law, Rosemary Langford. Professor Langford, thank you.
Thank you. As Matthew said, I'm Rosemary Langford. I'm Director of Melbourne Centre for Commercial Law, where Matthew is one of our construction law program directors. So I just want to close very briefly tonight by saying huge congratulations to Matthew on such an impressive publication. You've set the bar very high for all of us, particularly with the extensive updating. So I was going to get us to raise our glass, but most of us don't have glasses. So I've no doubt that an extraordinary amount of work went into the publication, and you must be very pleased with the outcome. So please join me all again in congratulating Matthew.